Rob, thank you very much for that. I'll start, if I may, with a brief explanation and an apology. The explanation is that my task this evening, as I understand it, is to keep talking until Jeremy Corbyn arrives. although I can't guarantee that if he arrives while I'm still talking, I'll stop. The apology is that I'm not going to talk about the United Nations, despite the august nature of this gathering. I did spend 4 years at the United Nations before most of you were born, and it was a formative experience, and I'm a ferocious supporter of the UN. But I want to talk this evening about something else, which is the Special Immigration Appeals Commission mentioned by Rob in his introduction. To my own enormous surprise, I was invited to be a founder member of the Special Immigration Appeals Commission, which I shall now call SIAC, although some people call it SIAC. Anyway, SIAC. This is a body which was set up in 1997, 1998, to hear appeals from people, aliens, foreigners in the UK, whom the Home Secretary wanted to deport, but who, where the grounds for deportation involved national security. There's a well-known body of courts of appeal to which ordinary deportees can appeal, but there are certain cases where the evidence on which the wish to deport an alien involve national security and sensitive information, where it's difficult for the full reasons to be deployed in court. So SIAC was created with a series of very unusual and unprecedented provisions for its proceedings. First of all, let me say that the composition of SIAC in itself rather peculiar. There are three nominally judges actually who sit in each particular case, and there's a panel of members of SIAC from which the three are drawn in for each particular appeal. The chairman is a High Court judge. The second member is a county court level judge, and the third member is a layman, not necessarily a lawyer at all, but somebody who has experience of dealing with sensitive security and intelligence matters, which are obviously relevant to national security deportation cases. In my case, as you've heard, I'm a former diplomat, and as a diplomat I had high security clearances. So my function really in SIAC was to advise the other two members on the soundness and reliability of intelligence and security information, which was part of the government's case for deporting the person appealing against deportation. Other lay members included a former head of MI5, the Security Service, and a former permanent secretary at the Northern Ireland office, all people who had extensive experience of intelligence and security matters. So I happened to be the lay member on SIAC's first ever case, which occupied the first 4 years of SIAC's existence, actually. The case involved an appeal against deportation by a Muslim cleric from the Midlands, whom the Home Secretary wanted to deport as a danger to national security. And this was his appeal against deportation. The first thing that we had to decide was whether to accept the Home Office's case for holding some of the hearings in secret to hear some particularly sensitive information. And this is really a major theme of SIAC problems. Obviously, in the campaign against terrorism, which even the most bright-eyed libertarian, I think, would agree is not something that can be ignored in our country or in any other. One of the principal instruments for preempting terrorism is obviously paid informers. People who risk their lives, actually, certainly risk their positions in their societies by secretly providing information about what's going on in their own communities to the security service or to the police or to whoever is handling them. Now, if the information provided by an informer is deployed as evidence in court in the presence of the appellant, the person that the Home Secretary wants to deport, obviously it may well become easy to guess from the nature of the evidence who has supplied it. And this could have catastrophic effects, not only for the individual who has blown the whistle, but also, of course, on the efforts of the security service to recruit further informers in other situations. If it becomes clear that the information that you provide secretly is going to be divulged and exposed in court in the presence of the person who you blew the whistle on, then obviously you're going to think twice about providing any more information, because obviously you're liable to be identified. And recruitment of informers is as I say, a major weapon in the attempt to discover what's going on and prevent acts of terrorism. So the Home Office provided a huge amount of information and labelled a lot of it as closed information. They wanted to deploy this information in SEAC without the presence of the appellant, the man to be deported, or his lawyer, and there's provision for this in the SEAC Act. The two judges and myself, looked through all this material. Quite a lot of it we decided didn't have to be produced in closed session, and we insisted that it could be, if it was to be deployed at all, it must be in open session. We thought there would be no harm in having it exposed to the appellant and his lawyers. But quite a lot of it was obviously couldn't be heard in open court in the presence of the appellant, and we accepted the Home Office case that some of it should be heard in secret. Now, the strange provision in SEAC for closed evidence is that there's a barrister, a QC, who's appointed by the government to be the representative of the appellant, even in the closed hearings where the appellant is not present. He is security cleared, he's present at all the hearings of SEAC, and in the closed sessions when the appellant isn't there, he asks the questions, he cross-examines the witnesses, and he represents the interests of the appellant to SEAC. In the case which I heard, the special advocate, as this person is called, was fantastically effective. He was actually much more effective, I have to say, than the appellant's own lawyer. So we heard a certain amount of the evidence, not much of it, but a certain amount of it in closed session without the appellant present, and we heard the rest of the evidence. It lasted 2 or 3 months, with sessions every few weeks. And at the end of all this, we unanimously reached the conclusion that there was no real case for deporting this man. We didn't think that the Home Office case was very convincing, and so we allowed the appeal.